U.S. Attorney General Eric Holder has defended the FBI's methods in undercover anti-terrorism operations. American Muslim groups, though, have condemned the tactics used by the FBI in sting cases, saying they are in some cases a form of entrapment. Well, speaking to a group of Muslim Americans in San Francisco, Holder said, quote, "Those who characterize the FBI's activities in this case as entrapment simply do not have their facts straight or do not have a full understanding of the law. I am committed to using every available tool to protect the American people, but I will not sacrifice or compromise our civil liberties," end quote. Well, recent months have seen a string of arrests connected to FBI undercover operations. In October, Pakistani-born American Farooq Ahmed was arrested on charges of conspiring to bomb D.C. train stations after meeting with federal agents posing as al-Qaeda operatives. In November, Somali-American student Muhammad Asman Muhammad was arrested in an FBI sting after allegedly attempting to blow up an FBI-provided fake explosive at a holiday event in Oregon. Then in December, a Baltimore construction worker was charged with plotting to blow up a military recruiting station in Maryland. The FBI supplied him with a decoy car bomb. Well, critics of the FBI cite a 2007 case against Afghan Ahmadullah Niazi, the former FBI operative involved, saying he was trained by his handlers to spy on mosquegoers. Well, for more on these methods and their legality, we're joined by Shahid Buttar, civil rights lawyer and executive director of the Bill of Rights Defense Committee. So Eric Holder, Attorney General, is coming out pretty strong, saying that in fact the FBI methods are not a case of entrapment. They are not even bordering on entrapment. So why do so many feel just the opposite?
Well, it really reflects the inadequacy of the legal standard here. The bar for entrapment is to prove that the defendant had no predisposition at all to commit an offense, and that's a very permissive standard to the government. And so what the FBI does, uniquely in cases involving Muslims, is upon hearing of a potential threat, supply it, expand it, bribe people to participate, and then turn around and prosecute whoever gets involved as a supposed terrorist ring. And it really reflects a witch hunt tactic, which doesn't rise to the level of entrapment in particular cases, but absolutely violates civil liberties, and moreover is a very ineffective way of ensuring security, because it only alienates the same communities that, on the other hand, the Attorney General claims to want to reach out to.
And yet the Justice Department arguing you can't argue results. It's been since September 11th, 9 years of successfully making sure there isn't another large-scale attack on the United States. So how is this not an effective means?
Well, the first is that these sorts of tactics, as far as we know at least, didn't really start until the last few years. It's not as though this is the same thing that's been happening for the last decade, right? And if anything, the fact that these plots are now being uncovered and discovered indicates that unlike the immediate aftermath of 9/11, when there was no domestic terror threat from American Muslims, there was no concern about homegrown radicalization, unlike in Europe. The ground has shifted, and it reflects the fact that these communities have grown alienated by a decade of profiling. And now in the last few years, the FBI's powers have grown and expanded even further, and the concerns in the community reflect the predictable abuses of those policies.
So how do you strike a balance where you can ensure that rights are not violated, the Constitution is not violated, and yet there still is adequate methods of investigation?
It's not particularly challenging, quite frankly. I'd say there are two things in particular. The first is transparency, at least into the policies that are being used, right? Obviously, undercover operations need to remain secret, but the legal standards under which those operations are initiated, those should be known, especially when members of Congress and various public interest organizations have sought them, which is in fact the case, but they still remain secret. The second, beyond transparency, is just respect for a suspicion standard. The Fourth Amendment has long constrained, in the context of searches and seizures, police from arbitrarily stopping anyone. You have to have individualized suspicion. And the FBI, in its surveillance operations, respects neither the need for evidence nor individualized suspicion to justify its investigatory activities, and that in particular is a problem.
But isn't transparency also a problem? Isn't that sort of the equivalent of showing your hand in a card game?
I think not with respect to legal policies, right? I mean, it is if the idea was to show transparency of every operational case of surveillance, that would be showing your cards. But when we're talking about the object of transparency, if you will, is the legal predicate, what the FBI needs right? And the record is what the FBI's found, you know, in its various surveillance operations. How many times, like in Los Angeles, did the communities that were singled out for presumptive guilt infiltrated by paid FBI informants, rather than participating in the plots, go to the authorities and try to report the informant, which we know has happened, right? American Muslim communities have rejected FBI agent provocateurs in many different mosques.
Okay.
And what is really challenging here is that the FBI remains unaccountable and hasn't been held to account for those abuses.
Shahid, we appreciate you joining us. Shahid Buttar, civil rights lawyer here in Washington. Thank you.
Thank you.